Hello, everybody. Good morning. It's Dave Neal, stand-up comic and host of Bachelor Nation News. Happy Friday. We've got the footage from Wednesday's court meeting here between Clayton Echard and Jane Doe, and I got to tell you, it's pretty wild. There are moments where we see the folks in the background making faces in disbelief at some of the arguments that Jane's lawyer is making as to, the whereabouts of her unborn children. Absolutely wild stuff. Not to mention Clayton's lawyer raising his voice to call Jane Doe a liar. We're going to get into all of this right now. Follow me on Instagram at DNeals for stand-up show updates. I will be in Maricopa County March 28th for a stand-up show. I'll have ticket links to that pretty soon. Come to the show if you can. We're going to have a special guest, Clayton Echard, there to do a meet and greet after the show. It's going to be a ton of fun. That's the Thursday following the season finale of The Bachelor. So you're not going to want to miss that day. Clear your calendar, March 28th. And also don't forget, every morning and afternoon, Bachelor Rush Hour, the hit podcast. If you want to support the channel, the best free way to do that is to subscribe to the podcast and have a listen. I'll have a fantastic interview this weekend for you. All right, let's jump right into it. So here it is. It's just the first 8 minutes. This is from azcentral.com, which I believe is a subsidiary of USA Today. And my guess is the full meeting will be made available, which will be interesting. We've got Jane Doe on the left. I know we've redacted her face with the dodo bird there. And then we've got Woodnick Law next to Clayton right here, old Jerry Curl Clayton. And then Isabel Rainey, his his lawyer right behind him. And then we'll also see right behind Isabel is Greg Gillespie, also, someone who has been accused of crazy crimes by Jane Doe. She's got a restraining order against both of these men, but seems pretty comfortable to be there with them, exerting her power. Have a watch. I'll pause it in between and we'll kind of break this thing down.
Seated, please. Good morning, everyone. This is the time set in FC 2023-052-114. Appearances, please. Beginning first with Petitioner's Counsel.
Morning, Your Honor. Corey Keith appearing on behalf of Petitioner Laura
Corey
Owens.
Keith.
Myself and client are both present, appearing in person.
Good morning to you both, and from the respondent.
Good morning, Judge. Greg Woodnick. I've got Clayton Echard with me, and my associate Isabel Rainey is behind me.
Good morning to all three of you. All right.
Big fan of Isabel. Team Isabel Rainey out there, everybody. Come on, give some love for the woman behind Woodnick. She's put all the work in here, just crushing
This
it.
is the time set for status conference. As the parties both know, a motion to continue was filed. Mr. Woodnick, that was your motion, so I'll allow you to go first.
Judge, thank you. As the court is aware from the meetings, we have zero disclosure. And I don't think zero is an understatement. I did speak with counsel in the hallway. He indicated that disclosure was forthcoming, maybe as soon as later this week. I'll believe it when I see it, but in any event, we are not prepared to go to trial next week on any of the remaining issues because we have nothing. I'm asking the court to reset the trial for 45, 60 days, whatever the court's availability is, and I'm asking the court to give us 2 hours.
So he asked for 45 to 60 days. As we found out, he got more than that. So the court date was set to be February 27th, March 27th, April, May, June 10th. So over 90 days away. But that just is because that's what the judge has. Maybe they'll have a meeting and some court case will be dismissed and something will open up. We'll have to see. But I got to tell you what, flights to Scottsdale are going out of, who doesn't want to be here? We can be packed shoulder to shoulder to watch the public court do its work here.
Counsel?
Thank you, Your Honor. Your Honor, we're not opposing the motion to continue the trial. We're in agreement with the need for the continuance on the trial. I did want to address, we received the ruling regarding our motion for confidentiality this morning. There has been new evidence, threats to my client's life that were made to her on Facebook since the pleading practice regarding the motion practice regarding that motion for confidentiality.
Que convenient. So Corey Keith argues that there have been death threats made against Jane Doe, which I don't argue. The death threats, again, let's just put the timeline out there. I was being sued for harassment by Jane Doe. The night before she was set to sue me for harassment, she begged for a dismissal. This after months of telling me she was going to sue me, after months of telling me that she will dismiss this case if I take all of my videos down. none of which I have done. Although I will tell you this, the 7 videos that I did make private, I will be releasing to Patreon this weekend. Patreon will get the 7 videos that I made private that will now be back up. They're actually kind of interesting to look at back from October when we didn't know about some of the false evidence and the faulty fraudulent ultrasounds and those things. So very interesting stuff. But for the timeline, which is very important here, she asked me to sign paperwork saying I would never threaten to harm her or sick my audience against her or all these things. And I said, I'll absolutely sign that. That would be illegal. That would be inciting violence. I would never do that. I'm a pacifist. I don't want any violence whatsoever. I don't even pluck my weeds. I want everything to live. You know what I mean? No weed plucking over here. I grow out my, nothing gets plucked. No manscaping. We're all natural here, baby. I'm kidding. Anyway, it's Friday, folks. Leave me alone. So she asked for that, and I signed it. And then the next day, she dismissed the charge against me that I was harassing her. Bogus. I probably didn't have to sign it, but if I didn't sign it, she would have said, oh, Dave Neal didn't sign. I mean, she asked me a loaded question. It's like if someone said, hey, do you still beat your wife? If you say, no, I don't beat my wife, people are going to think, when did you stop beating your wife? It's a loaded question. So for her to ask me to stop inciting violence, it's like, I've never incited violence, and no, I won't incite violence. Either way, she gets a death threat from somebody on Facebook. This person, we don't know who they are. It could be her. It could be somebody else. We don't know. It's not me. I could tell you that. I don't know who it is, but I do know the person that was trolling her used photos from somebody in my Patreon. I believe they stole someone's identity. It's kind of complicated, and I would love it if the FBI looked into it. Unlike Jane Doe, who doesn't want information coming out, I would release all my records to help the FBI find out who's behind that death threat and pursue them to the extent of the law.
So I did want to have the opportunity to address that with the court, assuming that the court's position still remains the same with regards to that motion. I did indicate to Mr. Woodnick we will have discovery forthcoming by the end of the week with relation to my client's pregnancy records. Discovery has been requested far outside of the scope of what I believe is appropriate, and so I was hoping to be able to address that with the court as well.
And then you saw Woodnick just sighed there, going, ugh. Now, again, could it be a case where Jane Doe fakes a death threat onto herself and then claims, I need this case sealed because I'm getting harmed from the public? Yes. Could it also be a case where there's a crazy person online messing with Jane Doe and she's using it to her advantage? Also, yes. Both could be true.
Okay. All right. So we'll deal with the motion to continue first, then we'll deal with re-urging on the confidentiality and the discovery.
Your Honor, I believe my client went to the doctor in mid-November, and that's when it was determined that she had a miscarriage. We would believe that it was in the maybe month or 2 months leading up to that time.
So previous counsel should have disclosed that.
And then we look at Woodnick. He looks back like, are you effing kidding me? This is the moment that Corey Keith releases this. No one knew when she's in January said she's no longer pregnant. No one knew what her timeline would be since she claimed pregnancy well into December. And now Corey Keith says in November she found out she probably miscarried 2 months earlier. Guys, we shared this technique. We said, look, this is an argument she's probably going to make. She's going to say that she miscarried before the 20-week cutoff where she would need fetal death certificates. But rather than do that in November, she does that 3 months later. If you're not infuriated by this, you're probably not listening closely enough. The old saying goes, don't piss on my leg and tell me it's raining. Well, let me tell you something. We're getting the full Jane Doe golden shower moment happening right now.
Correct.
Well, Your Honor, I believe that the increasingly concerning nature of this case and the request for confidentiality and the request for the dismissal, I believe that given the fact that everything my client sends to respondent is being shared with the media, I believe that warrants at least some degree of the court finding her actions to be reasonable. She is actually receiving threats to her life, voicemails on her phone. I mean, this is concerning conduct from the public. And so we were just waiting on, same thing with the deposition. I told Mr. Woodnick we would appear for a deposition if the court ordered us to. We just wanted to have the motion to quash and the motion for confidentiality ruled on prior to doing so, because we wanted to have the court's input into if those things were necessary.
Now, no offense, but I've had death threats for, saying Greg Grippo wasn't gaslighting Katie Thurston. People online say and do the crazy things. Sometimes it's a serious threat, sometimes it's not. The threats made against her exposed her mother, but gave the wrong address. Okay, they gave the wrong address to another lady with the same name, which leads me to believe that either A, the person perpetuating the threat didn't know her address, which would be pretty bogus, because it's easy to find anyone's address. You can find mine, you can find hers, you can find anyone's, right? Or B, she may have been behind the threats, or she may have known about them and was willing to continue to share them because they weren't actually threatening to her because they were sent to a wrong address.
But counsel, my follow-up question to you then would be, if she had disclosed it in November, wouldn't this case have simply gone away and these issues wouldn't remain?
Wow. Judge asking tough questions. Why didn't she just say in November she was no longer pregnant? Let's see if we get an honest answer from Corey Keith.
Well, no, Your Honor, because she did disclose the fact that she had a miscarriage. It's well documented in our pleadings. I understand that the medical record.
He says, no, she did disclose it. Again, in January, 2 months later, she disclosed she had a miscarriage. I could understand maybe taking a day or even a week to process the, and in any case, if you're not in trial, if you're not in a lawsuit with somebody, you would not tell anybody, it's just a very sensitive subject. But for Corey Keith, and again, I get it, he's doing his job, but for him to have a straight face in answer, and again, the judge is going to decide who's paying this bill, and he doesn't even give the judge an honest answer. This isn't some crazy cross-examination moment. He just doesn't give her, he gives her a half answer that doesn't directly answer the question she's asking, which is, why didn't she disclose this in November when she found out?
In our pleadings, I understand that the medical record either, but my client does have a patient. It's well documented in our pleadings. I understand that the medical record either, but my client does have a patient. She has privileges that in this case are not only being not considered or not fully considered, but it's being taken even further, and her documents are being, I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that. I understand where the court is coming from, and I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents.
See, we need to do more than see the documents. This is why sometimes the public gets involved, because it's one thing to see a document, but she's already been accused very credibly of faking legal documents in previous court cases. She's already been exposed as faking ultrasound images, ultrasound videos, reverse Google image searching from previous cases. This case, a 7-year-old video was used and hijacked as her own with her name placed on top of it. She's claimed other people did this on her behalf. She fucking did this. We know that. So to say, hey, we offered to show the evidence. Could you imagine she faked all of that evidence and now she's actually got real evidence? Not buying it. Not buying it.
And we've had some discussion about that. Obviously, the recent pleadings, I think, may change that from the court. But it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
And Isabel just whispered into Woodnick's ear, old Isabel coming in from the top ropes.
All right, we'll have the minute at three reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways. I don't want anyone releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways and truthfully should go without saying, but I recognize it does not in this case. I am going to order that the records be disclosed dating back to August of 2020. That's 1 year prior to the first filing. I think that that's appropriate.
And then at that moment, we actually see Woodnick go and look at Greg Gillespie. Let's go backwards here. He looks at Greg Gillespie because Greg Gillespie's doing the math going, oh my gosh, they're going to get the medical records back to August of 2020. This is before he ever even met her on their little one-night stand, hookup or
2020.
Whatever.
That's 1 year prior.
Look at this. And you see them. He looks back and he goes, huh?
I think that's appropriate.
Clayton nods his
I
head.
appreciate that Your Honor's not living this case every day, but the statement of counsel was just that mother says she had a miscarriage 2 months before November.
I love that they call her mother. Is this standard in the legal world for family court? Mother Dodo.
In November, the parties appeared in front of Judge Gail Ketsis, where mother had a pregnant belly and told Judge Gail Ketsis she was 100% pregnant by my client. Your Honor's not adjudicating that today, but I'm asking Your Honor to take back the protective order proceeding that was granted in my client's favor for purposes of not consolidation, to be heard concurrently for the purposes of attorney's fees and sanctions on that matter.
All right, so what Woodnick is asking for is he's saying when Clayton had to go to court for his IAH, his injunction against harassment against Jane Doe, because she sent over 500 unwelcomed messages, because he would block her and she would unblock it, Judge Gelkekis adamantly agreed with Clayton and sided with Clayton to say, yes, you should get an injunction against harassment against her. She is no longer allowed to contact you. It's essentially a restraining order, right? With this new information coming out, Woodnick saying, we would like to go back, even though my client already won, and try to get attorney's fees from her for that case as well, because in that case, she should have known she wasn't pregnant at that time, and that information wasn't disclosed.
Because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding.
All right, so he just said she lied, and then Janie Dodo Bird leans over and is not happy. She's trying to discuss legal strategy. We're getting really into the thick of the things here. Watch the reactions happening. There's a lot going on here. We need the Law and Order music. Let's party. Come on, it's Friday.
On that matter, because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding, then I think that's sanctionable, and Your Honor could enter orders under that proceeding. So
she just did this and did that. She do something. She's doing that manic. Come on, we 2 times. I did that. You know, she's kind of like becoming Kramer from Seinfeld. You know,
Your Honor to take not jurisdiction, but to hear that matter concurrently, or to have that file available for our upcoming evidentiary hearing.
She lied. Should we have? By the way, should we make that? Should we get some audio of that? She lied.
Proceeding. Then I think that's sanctionable, and Your Honor could enter orders under that proceeding. So I'm asking Your Honor to take not jurisdiction, but to hear that matter concurrently, or to have that file available for our upcoming evidentiary hearing.
Response?
Your Honor, I would ask the court to deny that request. Spoken to experts in this case preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. That I'm not saying that is the circumstance here.
Okay, watch this and look at the reaction from Woodnick, from Gillespie, and from Isabel. They're all looking around like, is he really? Is this the move? You know, it's almost like you're playing poker with someone and you think someone has a genius hand, and then you find out they have nothing, and you're like, what? That was the big play? That was your big Trojan horse moment here to say she didn't know she miscarried, which would have been 4, 5, 6 months into a pregnancy. I mean, could you find, and this is what they're going to do, could you find anecdotal evidence of somebody who miscarried and didn't know it? I'm sure there's science to prove everything. I mean, gosh, we have a fucking stingray that just got knocked up in the zoo. Are they going to bring the stingray in as evidence? Your Honor, I've got this stingray here who is pregnant and never, the stingray only gave a blowjob to the hammerhead shark. I mean, what do you want from us? It's science. It's the zoo. We'll have to see. So let's go backwards and just look at the reaction of all parties related to Clayton. By the way, big group happening. No social distancing. Everyone's on Clayton's side. The only person that's on Jane Doe's side in the back left corner is the reporter from AZ Central. which is fine. I mean, he's not there siding with her. If this were a wedding, you'd say, well, one party of this wedding does not have a fun family.
It's preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. I'm not saying that is the circumstance here. I certainly wasn't present. Saying that my client has not lied in this case. She has not.
All right, so Corey Keith says he wasn't present, so we now have an update here. We can finally know for sure that Corey Keith not involved in the freaky deaky one-night stand known as Clayton and Dodo Bird here, so that's good to know. So he wasn't there, yet he knows for sure she was pregnant. The only thing Corey hopes for in this case is that his check clears from her. That's the only thing he can hope for.
Not intentionally lied to the court. Whether or not she was pregnant on that date, I think she could have testified that she was pregnant and she could have had a miscarriage days prior. I don't know, but I believe that the testimony in her deposition, the testimony in her final trial, and the expert testimony that will come with it will make those things clear. I believe it'd be.
Can't wait to hear this expert testimony. Here's what's going to happen. Corey Keith is going to bring in some expert, which again, you pay an expert to be there. You can find an expert to argue anything in the world. You can find an expert to say I'm the best power recapper in the world, and you can find an expert to say I'm the worst. You know what I mean? They come in all shapes and sizes. They don't really mean too much, especially in this case. The judge is going to listen to that expert and go, cool, here's what's going to happen. And again, sensitive topic as we're discussing here, miscarriage, stillbirth, child loss, things like that. This expert is going to rip up wounds that people have from mourning. I've got a close family who didn't have a miscarriage, but they lost their baby, weeks into a birth where, they just couldn't, there were issues that they couldn't resolve, right? And the family has suffered for years over this tragedy. So many people silently suffer because a lot of times miscarriages sometimes happen before you tell your family that you're pregnant. And in those cases, a lot of people, and I don't think this is the right way to do it, but a lot of people are left suffering silently. And you know what they do? They swallow that pain and they hold on to it and it festers. And in moments, as we're about to see, people that have had real suffering over real pregnancies, maybe after a gender reveal party, maybe after they put the crib together, after they told their friends, after years of trying, whatever their story may be, what we're about to watch is Corey Keith making a legal argument that absolutely shits all over people's real lived experiences in this quack role play. I'm the victim in court. I'm going to wear my cute victim court outfit and try to beat these big bad men argument. Corey Keith, I get it. Maybe you took this case before seeing how deep you're getting into it. I understand. Maybe I'm in traffic court and there's some loophole that I can get my guy out of a DUI. This ain't it, man. You're going up against all of the suffering and pain that so many people have faced by arguing that people can't feel a miscarriage. Because maybe 1 in a million can't. But most people have a lot of pain and suffering. Some, when you miscarry late into, a term, have to get surgery done, have to, go to the hospital and deal with the pain and the physical, the emotional. I am rip shit angry. And again, I'm not saying go hate on Corey Keith. He's just doing his job to defend his client. The person anyone should focus their anger towards is the person who's lying and weaponizing very personal and private moments in people's lives and hiding behind that and saying, no one can see my records here. And now months later, claiming that months ago, she found out that months earlier, she had this thing. Get the fuck out of here with this shit.
Absolutely inappropriate to throw out previous proceedings in this case. Based on my statement, not even my client's statement, there would need to be an evidentiary hearing in order for that to be proper.
But I think that's what he's asking. He's asking that the evidentiary hearing be wrapped into this.
And Your Honor, that's not appropriate. The evidentiary hearing has already been done. And
wow, we got plenty of time. The court's wide open. Why not wrap it all? Let's bundle it all together. Bring Gillespie and Maricini and Andrew and Matthew. Bring them all in. Come on, let's bundle it all. Throw my thing in there. What do they call this? The old class action party? Let's do it.
Like I said, my client's statements that were made during that hearing were true to the best of her knowledge. The reality here is sometimes women believe that they're still pregnant when they've had a miscarriage, and they don't know until they go to the doctor that their levels are no longer appropriate for a pregnant woman.
Imagine a male lawyer explaining this to a female judge. I tell you what, let's just wait and see on June 10th how this all plays out. Not a betting man. I don't think it's going to go too well for Corey Keith.
I do believe that is what occurred in this case. Timing wise, I don't know if any of us will ever be able to tell exactly when that miscarriage took place. But I do know that my client from our conversations did testify truthfully, and there were not misstatements that were made there. We're certainly not intending to change her testimony.
And they say she wasn't intending to change her testimony. Well, as we reported yesterday, her December Medium article deleted out snippets about her pregnancy. She has no problem changing her testimony. She has no problem changing the article she's written. She has no problem deleting things. She has no problem taking other people's evidence and using it as hers. She's the ultimate manipulator in the sense that, I mean, I don't know, does she go to yoga because she's so good at stretching a bare truth, a tiny, I tested positive on this, to now saying that she's got, so again, everyone's done the hypothetical. So you're telling me that she miscarried 1 to 2 months prior to November. Well, then why end of October did she have a giant belly? I mean, that belly she had was bigger than my wife's pregnant belly, and we're 7+ months pregnant with one baby. She was allegedly pregnant with twins. It ain't true. It ain't true. And they're going to argue that, well, she didn't know, so maybe she was bloated. She had a burrito, and next thing you know, she ate too many kidney beans. So she was, she looked big. We need the smoking gun evidence that she purchased the baby bump. We need the smoking gun evidence that she purchased the ultrasound photo. We need the smoking gun evidence that Chase J. Jones is her, and it was, a ruse to cancel Clayton. Will somebody who has some of this information drop it in my email, please? I don't expose my sources here, but can we get the smoking gun here? And so, get her in her deep pockets to pay these bills and never have to deal with this again.
But like I said, we have spoken to experts that have identified that sort of occurrence does sometimes happen.
Follow-up question to his comments. Counsel, are you asking that I revisit the order against harassment or just for purposes of fees and costs?
Just for purposes of fees and costs, because the order was appropriate that Judge Gelkatzis entered. However, she did not order fees and costs. I would contend that if she knew what we think the evidence will show, which was that Ms. Owens just lied and said she was 24 weeks pregnant with twins, and then apparently had a miscarriage apparently 2 months earlier, that had she, if any of that is true, that had she known that was her testimony at the time, she would have ordered attorney's fees in Mr. Eckerd's favor, and I'd like that to be on the table at the evidentiary hearing.
There it is, folks. So that's all we have, and that was from azcentral.com. The article was written, I don't have the author's name off the top of my head, but wild stuff. And how it all ends, we'll be covering it. I'll be live on Patreon this morning at a different time. 10 a.m. Central Standard Time is when I'll be live. If you want to join me there, patreon.com/Dave Neal. Oh boy. How does that not piss anybody off? Well, we'll have to see what the evidence points to. If it changes and she's got all this miraculous evidence we never knew about, we'll call it the immaculate evidence to go along with the immaculate twins. We will be here to cover it. All right, folks, we'll be back with more content right after this.